And then finally, I'm going to tell you how the trial will proceed. Since many of you haven't served on a jury before, so this should help you in understanding how a trial proceeds and what is expected of you during the trial. Now, you've been selected and sworn to try the following: the criminal case of the state of Georgia versus Marquavius Huey. The Fulton County Grand Jury has indicted the defendant Marquavius Huey with the following offenses, which I'll read to you: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, armed robbery, aggravated assault with a deadly weapon, aggravated assault with a deadly weapon, possession of a firearm and a commission of a felony, possession of a firearm and a commission of a felony, armed robbery, aggravated assault with a deadly weapon, aggravated assault with a deadly weapon, hijacking a motor vehicle in the first degree, possession of a firearm and a commission of a felony, possession of a firearm and a commission of a felony, participation in criminal street gang activity, participation in criminal street gang activity, participation in criminal street gang activity, possession of a weapon by an incarcerated individual, possession of a telecommunication device by an incarcerated individual, and participation in criminal street gang activity. The criminal case of the state of Georgia versus DeMonte Kendrick. The Fulton County Grand Jury has indicted the defendant DeMonte Kendrick for the following crimes, which I'll read to you now: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, murder, participation in criminal street gang activity, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, possession of a firearm and a commission of a felony, possession of a machine gun, and possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm. Criminal case of the state of Georgia versus Quamarius Nichols. The Fulton County Grand Jury has indicted the defendant Quamarius Nichols for the following crimes, which I'll read to you now: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, murder, participation in criminal street gang activity, participation in criminal street gang activity, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, possession of a firearm and commission of a felony, and possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm. The criminal case for the state of Georgia versus Rodeus Ryan. The Fulton County Grand Jury has indicted the defendant Rodeus Ryan for the following crime, which I will read to you now: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act. The criminal case of the state of Georgia versus Shannon Stillwell. The Fulton County Grand Jury has indicted the defendant Shannon Stillwell for the following crimes, which I will now read to you: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, murder, participation in criminal street gang activity, participation in criminal street gang activity, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, possession of a firearm in a commission of a felony, and possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm. The criminal case of the state of Georgia versus Jeffrey Williams. The Fulton County Grand Jury has indicted the defendant Jeffrey Williams for the following crimes, which I will now read to you: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, participation in criminal street gang activity, participation in criminal street gang activity, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, possession of a firearm and a commission of a felony, and possession of a machine gun. Each of the defendants have pled not guilty to this indictment, and each of them deny every charge in it. This indictment and the defendant's pleas of not guilty present the issue that you've been selected and sworn to decide. The indictment is the way the defendants are charged with committing crimes that violate the laws of Georgia. The charges in the indictment and the pleas of not guilty are not evidence of guilt, and you may not conclude that the defendants are guilty based on the charges or the not guilty pleas. Each of the defendants is presumed to be innocent until he is individually proven guilty. The defendants begin the trial with a presumption of innocence in their favor, and this presumption stays with them until it is overcome by the state with evidence that convinces you beyond a reasonable doubt that the defendants are guilty of the crimes charged. You may not convict any one of the defendants of any crime unless each element of the crime is proved beyond a reasonable doubt. The burden of proof is on the state to prove every essential element of the crimes charged in the indictment beyond a reasonable doubt. The defendants have no burden at all, and the burden never shifts to any one of the defendants to prove his innocence. However, the state is not required to prove the guilt of the defendants beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which you can give a reason based on a consideration of the evidence or a lack of evidence, a conflict in the evidence, or any combination of these. After considering all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must find the defendants not guilty. But if no reasonable doubt exists in your minds about the defendant's guilt, then you may convict the defendants. If the state does not prove the defendant's guilt beyond a reasonable doubt, your duty would be to find the defendants not guilty. My role is to determine the law that applies to this case. Then I will instruct you on the law that you must apply to the facts in reaching a verdict. I'm giving you some of those instructions now. I will give you more detailed instructions at the end of the trial. The jury has a very important role. You must decide the facts of the case from the evidence presented and then apply the law that I give you to those facts. Evidence is how a fact is proved or disproved. Evidence can be either testimonial or exhibits. Testimony is what you'll hear from people who take the witness stand right here and swear to tell the truth. However, the questions the lawyers ask the witnesses are not evidence. Exhibits are documents, photographs, and other physical items that are admitted during trial. The object of this trial is to discover the truth. During the trial, I will admit evidence according to the rules of evidence. Those rules are designed to aid in discovering the truth by making sure that you consider only the best and highest evidence. The lawyers are advocates for their clients, and they have the duty to represent their clients to the best of their ability. They must follow the rules of law, trial procedure, and evidence during the trial. They may make motions or objections if they believe that any rule is not being followed. Remember, what the lawyers say in making or responding to objections is not evidence. I will admit or exclude evidence according to the rules. If the lawyers make an objection and I overrule it, that means the evidence is admitted and you may consider it. On the other hand, if I sustain an objection, this means the evidence is excluded from the trial and you may not consider it. You should consider only that testimony and only those exhibits that are admitted. You should not assume or infer anything about evidence which I have excluded. If you happen to hear or see evidence that I end up excluding from the trial, you must disregard it entirely in your deliberations and in arriving at your verdict. None of my decisions and nothing I say during the trial are evidence. My decisions and remarks do not mean that I favor or lean to one side or another in this case. I am only interested in seeing that this case is fairly tried based upon the laws and Constitution of the state of Georgia and the Constitution of the United States. Sometimes I may have to deal with the lawyers' motions or objections without you being here in the courtroom, and so I'll excuse you from the jury room. So what I'll say, ladies and gentlemen, is, ladies and gentlemen, there's a matter we need to take up. If you retire to your headquarters, your jury deliberation room, and I'll wait further instruction. That's my most artful way of telling you need to take up something outside your presence in hearing, okay? I'll try and limit those interruptions, and I ask that you be patient when they do happen. I can't tell you when those will happen, but sometimes they do. So please I'll ask for your patience in advance on that particular matter. So, the trial will proceed as follows. First, the attorneys may give what's called opening statements. No attorney is required to make an opening statement. Opening statements are not evidence. There's simply an introduction to the evidence, a preview, or an outline of the expected evidence. The state goes first because they have the burden of proof. Second, the evidence will be presented. Third, the lawyers may give closing arguments or summations. They may discuss the law that applies to this case and how you should consider the law in light of the evidence. They may also point out evidence that they believe supports their position. What the lawyers say in closing arguments is not evidence. The goal of a closing argument is to persuade you to decide the case in their favor. Fourth, then I will explain to you the specific law that applies to this case. This is referred to as charging the jury. I will then ask you to go to the jury room, your headquarters, to deliberate and to reach your verdict. It is important that you pay close attention during this trial. If at any time you cannot hear or see any evidence, or you're suffering from any discomfort that distracts you, please inform me or one of my deputies or my team, and we'll do whatever is needed to make sure you can hear and see the evidence and give it your undivided attention. If you need a break at any point in time, please raise your hand or alert one of our deputies. The jurors are not allowed to question witnesses. However, if you have a question you believe is important for your determination of facts, please write down your question, give it to one of the deputies, and I will determine whether or not it should be asked. If you have a question while the evidence is being presented, please keep in mind that you do not yet heard all of the evidence, and your question may be answered by the time the rest of the evidence has been presented. You should only consider evidence with an open, or you should consider the evidence with an open mind, and you should not reach any final conclusions until the trial is over. Do not jump to conclusions before all the evidence is presented. To maintain the integrity of the jury system, I'm going to remind you again, remember my ad nauseum admonitions? Okay, y'all shaking your heads like, okay, we're going to go through this one more time. I'm going to remind you that you must decide this case only based on the evidence admitted during the trial and the law I will explain to you. You may not conduct any research on your own about this case or about any people or places mentioned during the trial. You may not visit any places mentioned in the evidence. You may not refer to any books or documents that were not admitted during the trial. You may not use any dictionaries or other reference materials. You may not use Google or any other search engines or any other resource matters, the internet, websites, or blogs. You may not use any other electronic media to get information about this case. You should not use any of the sources to get any information about the legal terms or about the law. And finally, you may not listen to any accounts of this trial that may appear in the news media, whether it's online, in print, on the radio, on your cell phones, or any other smart devices that you may have, or any other mediums. Remember, you are the ones that have been qualified as fair and impartial jurors deciding this case. No other influence should affect your decision. For that reason, as I mentioned earlier, part of my admonitions, you may not discuss this case with anyone, including your family and friends, or let anyone discuss this case with you or around you or in your presence. This includes discussing or sharing information by email, text, blogging, or other form of social media until actual deliberations begin. That is, until after you've heard all the evidence, the lawyer's closing arguments, the law that applies to this case. You must not discuss the case even amongst yourselves in the jury room, during breaks, or elsewhere. Remember I told you would it be a violation for you to sit back in your headquarters jury deliberation room after we take the first witness? Say, what do you think? Is that a violation? Yes. Come on now. We all got to kind of shake our heads. Yes. Would it be a violation for you to, as you're walking lunch, to recap and discuss the case? What about you in the bathroom? That's creepy. Remember I told you about that before? Okay, all right. So we're not going to do that, all right? But what about going to the jury shuttle? Yeah, that would be a violation as well. Okay, what about if you're walking in onesies and twosies? All right, okay. And how did I tell you you're probably going to get caught if you violate my admonitions? You're going to tell on yourself. That's right. Or somebody's going to tell me that you've been on some particular site or some particular issue. And you all have really learned that. Okay, I'm proud of you. All right. But it's really important, ladies and gentlemen, because remember I told you, fair trial, just trial, lawful trial. So all of these things are really important in terms of the admonitions and how serious we are about you not being only hearing what's in this courtroom and only the cases presented to you. All right? So you've been given pencils and writing utensils and pads for your note-taking and use during this trial. So what I want you to do at this point in time is take and open your pad to the very first page. For those of you that have them, okay? For the rest of you, I'm gonna get you a pad, all right? Okay, does everybody have a pad? Okay. Okay. All right. Who else doesn't have a pad? Feel like we have enough, or we'll get you one during the break. What I need you to do with all of you that have pads, go ahead and write your name on the very first page. Okay, that's your pad, okay? So whenever you come back in, after breaks and everything else, if you're going to your headquarters, just leave your pad inside the basket, okay? We're not going to take a look at it, and nobody's going to bother with it. Who else needs a pad? Everybody got a writing utensil? Pen or pencil? Okay, for those of you who who just got passed, go ahead and write your name on the very first page, inside cover. Just go ahead and write your name on it. And believe me, we have more pads, so if you get, by the time the trial ends, if you need another pad, we'll give you another one, okay? So, but leave them in your headquarters when you have breaks and go outside and for the end of the day. Just put them in there, take another jury sticker out, and that will be kind of your way to kind of just trade and make sure don't take them home with you. Then the next morning you can find your pad and you can kind of just be prepared to take notes. Okay? So I'm going to tell you that again. Just leave your pads as you have breaks and everything else in your headquarters. And at the end of the day, like I said before, we will secure your notes. That'll probably be Miss Umano's job. And we'll just leave them in the basket, and we put the basket in a secure location, and then we bring the basket back down, so when you come back tomorrow morning, or whatever morning you come back, you'll have your notepad, all right? Now, but please keep in mind, all right, you may take notes if you wish. If you do take notes, please do not let your note-taking distract you from paying full attention to all the evidence and the witnesses. You may not share or discuss your notes with anyone until you start deliberating at the end of the case, and I tell you how you to begin the deliberative process. Notes are not evidence, they're only memory aids. They are not more important than your own impression or memory of what the evidence may have been. You may consider another juror's notes to refresh your memory. You should only rely on your own memory of the proceedings. Do not be influenced by the notes of other jurors unless their notes help you in determining your own independent memory. You must leave your notes in the jury room except when you are in the courtroom. They will be collected by the court and destroyed at the end after you finish your deliberations. Ladies and gentlemen, you will not get a transcript of any witness testimony, so please remember what they said on the witness stand in a way that works best for you. Okay? I'm going to tell you a couple other administrative, or as I call administrative. Ladies and gentlemen, I've tried a lot of jury cases, so some of the things I'm going to say to you are the result of debriefing a lot of other citizens. One of the questions I get on a routine basis is, Judge, what are you doing up here on the bench? all right? So I'm going to demystify that, and I'll tell you right now. So there won't be any question about what I'm doing, okay? All right. So, as I told you earlier, I'm responsible for just about everything that goes on in this courtroom. So, on the bench here, I do have a phone, and I can make certain phone calls I need to. These devices here, ladies and gentlemen, you're going to see us use them from time to time. They are audio devices that each pair of litigants has on their table to allow them to hear bench conferences, because I may have to take up things out that I told you outside your presence and hearing, but we may not want to put you out of the courtroom, so we may come up here, I cut my microphone off, and everybody using these devices is able to hear the bench conference that I'm having. Will you be able to hear the bench conference? No. It's not for you to hear. So, but these devices allow us to do that. So if you see people putting on these particular devices to talk, such as this, you'll know that that's what's going on, okay? All right. To my left, I do have a computer. I have a couple of different programs that are open that help me do legal research and other things to keep track of what's going on during the trial. And otherwise, I'm taking notes. So if you see me typing, don't assume I'm booking my next vacation. I could probably be doing that, but I'm not. I do take notes, and I do, pay attention to what's going on. I of course, I'm very interested in your comfortability, and I monitor everything that's going on here in the courtroom. So that's what I'm doing up here on the bench. All right. One other thing that you might hear behind me is this bell that starts jingling, all right? And if you hear a jingling sound like a bell, please don't think that I'm doing anything creepy up here, all right? I have a service dog behind me. His name is Jack. I think some of you may have seen him already. He lives the best life ever. He's pampered. He's really, and he is a Labrador Retriever. He's about almost 2.5, 3 years old at this point in time. So, but if you hear that bell, that's him moving around, all right? He doesn't bark. He rarely gets interested in what's going on, so he might come up here and look, but that's about it, all right? Don't bring him any food either, okay? All right? He is spoiled and rotten, so please don't try and throw any food back here behind me or anything like that. He doesn't need anything else, okay? But if you hear that bell, hear that sound, that's what's going on behind me, and he'll get up when we have breaks and whatever else. So, but that's if you hear the bell, that's Jack. All right. Ladies and gentlemen, I think we're ready for the lawyers to begin their opening statements, and what we'll do is we'll probably go till probably about 12:15 or so, and then whatever we don't get done, we'll just continue on at that point in time when you all come back from lunch, okay? So at this point in time, counsels, I'm going to invoke the rule of sequestration as to both sides. So anybody who's going to give testimony in this case, if you please absent yourself from the courtroom, please don't discuss your testimony to anybody except the attorneys in this case. So at this point in time, does the state wish to make an opening statement?
The state does, Your
All
Honor.
right, go right ahead now.
Your Honor, I would ask the court regarding certain members that we have spoken with the court about in terms of witnesses, whether they are allowed to remain in the courtroom.
I believe the matter that we discussed, we won't be able to take up till Tuesday. So that person should probably be excluded.
Then,
That person.